we move to video number 3. Sir, in December 2009, there was a demand by some of the very prominent jurists and advocates, and your name was amongst them, wherein it was brought out that judicial appointments should be made only after a public debate. Now, do you still subscribe to this view from 2009 to 23?
No, I am afraid I have second thoughts.
Okay.
Yeah, because
why is it so?
I'll tell you. You see, somehow we in India there's hardly any Indian who doesn't have two opinions. Hardly. He says one thing, he says something again. And therefore, it's very difficult to bring judges' appointments in the public domain. You may criticize that so-and-so should never have been appointed a judge, or so-and-so should be appointed and has not been appointed. There are both sets of cases. We can point out few judges in my time who should have been in the Supreme Court who are not in the Supreme Court. Few judges who should not have, never should have been appointed judges at all. Yes. Now, where does one stop? Because we have a proliferation of opinions. And who is right, who is wrong? You have to have some body. You call it a committee, call it a collegium, call it a commission, call it what you like. But yes, somebody who must ultimately take that decision. And I think the greater problem that arises is not so much on appointment, as you have said, but on transfer.
Okay. From one court to another.
Yeah, from one high court to another high court. Yes. And although it has been said that you cannot do this as a punishment, yes, it is almost invariably done as a punishment in practice. Everybody knows it. And that's why one of the judgments say that that's why you can't even look at the reasons why he was which is very odd. Right. It's very unfair also, very unfair. Because I may say something, I may have access to a particular judge, and I may say something entirely wrong about you, about someone else to him, yes, and he would act on it, and yes, it would be totally wrong, but that's yes, totally unfair, totally unfair.
Yes, sir. But moving on to, sir, that aspect relating to public debate,
yeah,
why is it that now you disfavor that suggestion?
Public debate again means, what does public debate mean? It's individual opinions.
Okay.
I mean, there's no forum, there's no official forum.
Proliferation of,
yes, a proliferation of opinion. Who should be appointed? You must trust somebody.
Now, sir, you have appeared in that famous judge's case,
yes,
so to say, and at different times you have commented on the matter relating to appointment, yes, bringing in the judges for, yes, the High Court.
Right, you are right.
How do you advocate now? What do you think would be the proper way?
I have considered that, you are right. I have myself said that the collegium system hasn't worked at all. And I still believe that it still hasn't worked. With three judges or 5 judges. 3 judges in the High Courts, 5 judges for transfer, yes, Supreme Court, etc. It hasn't worked effectively. There have always been impediments. There have always been someone who says, appoint so-and-so, bring him to the court, and then 3 of them say no. And then what do? He's totally honest.
So what do you think? What's your gut feeling? Yes.
Perhaps the better approach is again the Venkatachaliah formula. Okay. The Venkatachaliah formula of a national commission, okay, was entirely different from the national commission that was ultimately brought. The Venkatachaliah, which actually resulted, that Venkatachaliah commission formula had resulted in one of the bills,
okay,
also the 103rd or 104th bill,
okay,
amendment bill,
yes,
where it was to be a commission of 5,
okay,
not 6, 5. And 5 was why 3 senior most judges of the Supreme Court.
Serving, yes.
Serving judges, 3 senior most, top. You have to trust them. If you don't trust them, who will you trust? add to that the law minister. You have to, because he brings another, and add to that one person as an expert or whatever it's called, by whatever name you call him. So that the majority always is with the 3 Supreme Court judges, so that there is no hanky-panky about it. Whereas the amendment that was brought when the actual matter came up for consideration was not merely 5 but 6. And it was 2 who were special people, outsiders, who had nothing to do with law, who may not be judges, who may not be lawyers even, who could outvote the 3.
That is what was not acceptable.
That was not accepted. And that is when criticized repeatedly that perhaps the judges themselves should have tweaked it. They could have been done, but it wasn't done anyway.
Thank you, sir. This brings us to the end of this video. And in the next video, we would have other questions, including the one on Justice Gogoi's appointment to the nomination to the Rajya Sabha. Thank you.